Hello, and welcome to Law and Democracy, a podcast of the Election Law program at The Ohio State University Moritz College of Law. I am Tony Goggin, professor of law and the Kern Family Chair in Law at Drake University Law School in Des Moines, Iowa, and I'm also a senior fellow in Ohio State's Election Law program. I'm joined today by Professor Stephen Huffner, the C. William O'Neill Professor in Law and Judicial Administration at the Ohio State Moritz College of Law. Steve is also the director of the Legislation Clinic and the deputy director of the Election Law program at Ohio State. Steve and I are joined by Professor Ann Ralph, the Morgan E. Shipman Professor in Law and Associate Dean for Academic Affairs and Strategic Initiatives at the Ohio State University Moritz College of Law, and is also a senior fellow in the Election Law program at Ohio State. We are thrilled today to be joined by Professor Lori Ringhand. Lori is the J. Alton Hosch Professor of Law and Josiah Meggs Distinguished Teaching Professor at the University of Georgia School of Law, where she has taught since 2008. Professor Ringhand is a nationally known Supreme Court scholar and author of the brand new book, We the Voters, The Constitutional Choices That Shape America's Elections, which is forthcoming. Actually, it isn't forthcoming since I'm holding a copy of it. It's just been published in the last couple of weeks by Stanford University Press. And I'm very excited to have the opportunity to interview Lori about her new book. So Lori, welcome to the program.
Thank you so much. I'm thrilled to be here.
Oh, it's a pleasure to have you on the program. So my first question is, Lori, what inspired you to write this book?
Yeah, so I think like many of us over the last decade or so, I've become very aware of how many people don't necessarily understand some of the nuts and bolts of how our elections work and why. And that's kind of created an opportunity for misinformation and disinformation to seep into the discourse, even when people are not trying to be kind of partisan actors or whatnot. It's just sometimes when people don't have a firm grasp of what the system is, why it looks the way it does, it creates opportunities for mischief. And I've found that there's just a real hunger for people to want to know a little bit more, and thought that I could facilitate that by this type of book.
Well, you have a bunch of fans of the book on the podcast right now, but I want to ask for those who might be listening and have not had a chance to read the book yet, what are the main themes? What's your elevator pitch? What are the main themes of the book?
I'm terrible at elevator pitches.
We love election law, so it doesn't have to be an elevator pitch.
It can be kind of like an escalator pitch, a little slower. Yeah. And so the goal of the book is to help people understand what the rule structure in our democracy are and why they are that way in particular. And in the why they are that way, what I want people to understand is what the choices, the controversies, the compromises that we've made over the course of our history that have shaped our election law. What are the reasons behind them? What are the competing principles? Why are some of these questions genuinely hard when we think about the election rules? So what are they? Why are they the way they are? And what have the consequences of some of those choices been, to help people better understand why the system looks the way it does?
Can you give us some examples of sort of how the book walks through that?
Yeah. So the book, it covers an array of areas that I think are high profile areas that people care about but don't necessarily understand deeply. So, I open with the Declaration of Independence and the implications that the writing of the Declaration of Independence has for what we think about as the role of representative government as opposed to, other types of government. And we talk about the 1787 Constitution and fights about representation and why we have the Senate. And then from there, why we have the Electoral College in the next chapter. Why did that weird thing evolve the way that it did? And then move into some more nuts and bolts. Here are how election laws are structured in the division of power between the federal government and state governments, and move into Reconstruction and the Reconstruction amendments, and particularly the Voting Rights Act and the impact that has had. And all these choices have consequences for the way our elections work today. So I talk readers through why they were made and what those consequences have been.
There's a part of that that is really democratic theory, or at least the theory of American democracy.
Mm-hmm.
And I say that not in any critical way. I mean, election law is all about how we operationalize what our democratic theory is. So in structuring the book that way, I think it really can help ground the explanation of why we do what we do in the election context. I found myself wondering whether you had any story to tell about how you picked the title of the book, and how that relates to the interface between democratic theory and election law.
Yeah. So the title of the book was a little bit of a journey. This was not my original title. The publisher did not love my original title. What did I call it? I'm not going to remember. I called it something that was a little bit of a play on words, and the publisher thought it was maybe a bit too subtle. So we messed around with it a little bit. We landed on this. I think the publisher liked the idea, and I like the idea as well, of bringing the voter into the title to make it clear that this is a story about us. This is a story about what voters do, why we do it, how our votes translate into political power, and what we might change if we wanted to. So I did like that piece of it. It was before we didn't know anything about Jill Lepore's book that came out with a very, very similar title, We the People. I can only hope that when people Google for hers, maybe they land on mine by accident.
But yours, I mean, hers is understandably the title for what she's writing, and yours then becomes a kind of echo of the Constitution, and the familiar language with which the Constitution begins. And that's where I was seeing this intersection between democratic theory and law.
Well, and I think that I try to stay away from kind of academic discussions of deep theory, but the way that it's implicated and ties to the title, part of the story I'm telling here is the way who we the voters are has changed, right? The expansion of the electorate to enable more people to exercise political power over time. And that's a real important story of, what democracy in America is. Both in terms of how we think of it and in terms of how we operationalize it and what courts have done. The Reynolds v. Sims cases, for example, the one person one vote cases, that is very much a case grounded in political theory about what a vote should mean. And separately, who should be represented, which, the courts don't treat as the same thing.
Lori, could you talk a little bit more? You just made reference to a foundational election law case from the 1960s. Could you talk a little bit more about how in your book you show how history illuminates modern contemporary election law controversies and election law disputes?
Sure. I mean, when you look at, I'm in Georgia. So we have a lot of election news in Georgia. And most recently, what we have seen happening here in Fulton County, which is essentially where the city of Atlanta, we saw the Department of Justice confiscate through a search warrant ballots from the 2020 election. So we see this intersection of federal power and state power. So there's a state lawsuit right now about the validity of that search warrant and the choice to take those ballot documents. So, and what that represents is this tension between what the federal government can control over elections and what states can control over elections. That is a very newsworthy, hot topic right now, but it's not new. You know this, Tony, certainly. The division of power over elections between the federal government and the state government was one of the most controversial things at the ratifying convention of the 1787 Constitution. Under the original Constitution, the Constitution gave Congress really a lot of power, at least over federal elections. Congress can change state rules about the time, place, and manner of federal regulations or federal elections. That was extremely controversial. Very, very controversial, because it was seen as kind of this intrusion on something that states had traditionally done and thought that they were entitled to do. So we thought about it then. We get the time, place, and manner regulation. Then we go through the Civil War and Reconstruction. And we get another kind of layer of fighting over the division of authority between the federal government and state governments through the enforcement provisions of the Civil War amendments, which give Congress new power to make rules about both state and federal elections. And then we get controversies of today where we're still fighting about exactly where these lines are supposed to be. So, but those different aspects of our history have and continue to shape what that division of authority looks like.
One of the things I love about the book is that it covers both these big foundational moments, like the ones you've just been describing to us, but then also gets into the nuts and bolts of election administration, which I think people seem to have a lot of interest in right now, as you know, as we all should, as voters. So, why do you think it's important to go into the sort of nuts and bolts issues for people to understand how elections work?
So that nuts and bolts chapter was the hardest chapter for me to write. And in part because so much of it is state specific, and some of it's federalized. Not all of it is state specific, but a lot of it is. And a lot of it is in some ways kind of boring, describing the administrator or the behind the scenes procedures that go into counting ballots and auditing them and all that stuff. So it was challenging to figure out how to write that chapter without boring people to tears. But I thought it was really important because what I said in the introduction about what inspired me to read the book, one of the things that was very striking to me after the 2020 election, I was kind of eavesdropping around town to see just what people were saying about it. And, people were genuinely shocked that different states had different laws about things like how you register to vote, how late the polling places are open. Also things like when some of the challenges to the election in federal court were rejected on standing grounds, as a few of them were, kind of people assumed from that no court had ever laid eyes on the merits, right? So it really seemed like this is a place where there really is a vacuum of information, and explaining that all states have extensive legal regimes about how registration works, how ballots are cast, the way county clerks track them and know where they are. You can't just dump 700 ballots into the system and no one's somehow going to notice. And then what contest procedures are, how state laws have particular procedures and different people look at different types of questions at different times in that process. And just getting that information out there in kind of what I ended up doing with the book to manage the problem that these can be different in different states is to kind of focus on some of the commonality created by federal law, and there is a fair amount, and then try to look at just kind of what most states do most of the time to describe the procedures that a vote goes through and a voter goes through from registration to the point of a final decision. But that was hard. That was hard.
Given the anecdotal information you collected in 2020 and the surprise you just described that voters themselves were expressing about the variety of practices around the states, did that lead you to think that from the standpoint of broad public acceptance and understanding, there should be more uniformity here?
I think some more uniformity would be helpful, actually. I think there is value I think you can kind of sever responsibility in ways that get the best of both worlds. You can have some federal uniformity about requirements and some state independence in implementing them. So one of the great features of our election system is it's actually pretty hard to rig. And it's pretty hard to rig because you have thousands of actors across the country all acting independently of each other in the counting, in the tallying, in the reporting. That is just a very hard thing to crack if you're trying to steal a national election. That's a real benefit of our system. But I think I think you can keep the benefits of that while having more uniformity among what the basic rules of voting are. And I think it matters a lot what those rules would be. Obviously, not everything Congress is going to do is going to be, in any person's opinion, good or bad or better or worse. But I think as a kind of general matter, some uniformity would not be a bad thing.
I'll file that away for the Uniform Law Commission.
There you go. Do you agree with that, Steve, or do you think that there's more downsides than upsides?
Oh, no, I think I completely agree with that. And in fact, I'm only being a tiny bit facetious in referencing the Uniform Law Commission, which, has considered whether there would be value in having some kind of model election law that states could adopt. It would still not be a national or a federal law, but it would be promoting greater uniformity. And of course, the value that might come from that uniformity then runs up against the state independence and the desire states have to just be able to keep doing what they do. So I'll use that as a segue to ask you a different question, which is, you said earlier in our conversation today that you wanted to help people understand some of the historical origins of the election practices. And my own sense is that some of what we do is the result of some pretty conscious choice. And some of what we do, we've just kind of stumbled into, not with so much thought. And again, with this huge variation around the country. And I'm just curious whether that division makes any sense to you and what we make of that, if that is a fair division.
So I'm going to use this as my opportunity to talk about the Electoral College, which is probably not what you had in mind, but it is arguably something we stumbled into. So it's because it is built into, it's hardwired into the Constitution. It's baked into the constitutional cake. But it was kind of, we landed on this system because it seemed to be the thing that most people hated the least, which I suppose in a lot of ways could define how people feel about politics right now. But, we have the Electoral College. They looked at a lot of things before they designed this Electoral College system. And they were dealing with a bundle of concerns. They thought about letting state legislatures elect the president, but they didn't like that, especially once they decided that the president could run for re-election instead of having a single 7-year term, because they didn't want that dependence on other branches. They also didn't love state legislatures. The 1787 founders were not a big fan of what was going on in state legislatures at the time. They even thought about a direct popular vote, but the real concern there was that people simply wouldn't know enough about nationwide candidates. And this is horse and buggy times, right? That they simply wouldn't have the information needed to make good choices about nationwide candidates. So, James Madison described the Electoral College at one point as just kind of a function of exhaustion. And, I'm paraphrasing, but maybe not the best choice they ever made. So that's arguably something that we kind of stumbled into that has been historically very unpopular. It's been subject to more efforts to amend it than any other thing, but we still have it. And I think we still have it for the same reason. Very few people actually really like it, but we have very little agreement on what to replace it with. So we're still just kind of stumbling our way through it, and we keep making tweaks to it, to make it work a little bit better, to change things around the margins. But it's never been popular, but we don't have choices that we can agree on either.
Laura, you write about in your book not only the fact you addressed not only the fact that the Electoral College has never really been that popular, but also
Mhm.
that it's broken down, not just
Oh,
in recent times, but pretty much right out of the gate. Could you discuss that, the early problems with the
sure.
Electoral College?
Sure, yeah. So yeah, I mean it never worked. It quite literally never worked. So the first two presidential elections held under the new constitution involved George Washington. And George Washington, of course, was the consensus candidate. This was easy. Everybody voted for him as one of their two votes. And that was great. But then the first time that for the third presidential election, once Washington is off the scene, of course, then you have a choice, the first time where there's actually a contest for the top spot, right? And the result of that, what we get is John Adams and Thomas Jefferson as president and vice president, even though they represented essentially different factions that were developing. And the reason that happened is because the Electoral College system, as originally written, didn't differentiate between votes for president and votes for vice president. Every elector casts two. The person who gets the most votes is president. The person who gets the second most votes is vice president. So we end up with this weird thing where people who were essentially running against each other end up in the same administration. So that was kind of a mess. But then the next time around in 1800, it gets even messier, where Jefferson ends up in a tie with his running mate, because you have everyone cast two ballots and they were supposed to be essentially running as a team, but everyone who wanted to vote for the Jeffersonian Republicans, cast their votes for both of them, and suddenly they're in a tie. And the constitutional process requires a majority winner, or else, and a tie is not a majority. So it gets thrown into the House of Representatives, and that's still kind of the Federalist Party, which had been absolutely routed in this election, could swing the election. And we've got a situation here where there are governors of Virginia and a few other of the southern states, which are strongholds for Jefferson. They're actually thinking about marching militias into Washington if the lame duck Federalists try to take the presidency away and throw it to the Federalist candidate, to Adams, who came in a distant third. I mean, he was way behind. And so this was a mess. So we fix it almost immediately with the 12th Amendment, which fixes that problem. But then we have the Civil War challenges, right? And this whole electoral process, the Electoral Count Act process, assumes that the states will do their thing and send their slate of electors to Washington to be counted. And even in the contested elections after Washington, that happened. That wasn't the problem. The problem was this casting your votes for two people. But then in the immediate aftermath of the Civil War, we have this antecedent problem where there's a disagreement about who actually gets to speak for the state. You have some of these state legislatures. Reconstruction is falling at this point. It's failing at this point. And you have multiple entities in the state claiming to speak for the state legislature or for the state as the governor, and sending competing slates. And, nothing in the Electoral College tells us how to deal with that. So we get the Electoral Count Act, which is a long, ridiculous, extensive, badly written, disastrous piece of legislation that, we muddle through. Back to Steve's point, we kind of muddle through with that for a while. And then in 2020, we see how in the attempts to create kind of a controversy around the electors and how they should be counted there, we see some of the weaknesses in how that act is written, and we get the Electoral Count Reform Act. So we're always playing catch up. I guess would be my takeaway point on that. We're always fixing the most recent problem, but not anticipating the next one. And that has been the story of the Electoral College.
I had a question I intended to ask, but you just said something really interesting, which you've been interesting throughout, but this idea that we're not predicting the next problem.
Mm-hmm.
So I want to invite you to do just that. what keeps you up at night thinking about problems, election administration problems? What would you predict will be sort of the next front for election controversies?
Oh, I think we are going to see disputes, and this comes out of the Fulton County experience. The Fulton County, just to give you a little bit more background on that, this happened recently, but of course ties back to the ongoing insistence that the 2020 election in Georgia was inaccurately counted, or was rigged. And what has happened, the Georgia ballots were actually counted in full 3 times, including a statewide recount by hand. But there are, as there are in any election where lots of ballots are cast, there were some errors, there were some things that went wrong. That's kind of inevitable. But it is very clear that they were not outcome determinative in any way. We have counted our ballots multiple times. Despite that, the Department of Justice was concerned that there had been fraud in that election and got a warrant for all of the ballot materials and to take them all from Fulton County. And they're now sitting in a warehouse, and there's a judicial process in state court about what can and cannot be done with them. But here's what concerns me. If you read the affidavit supporting the search warrant, which normal people don't do, but I did. If you read the affidavit supporting the search warrant, the essence of the accusation was, yes, this series of things happened. We understand that the Elections Board and the Secretary of State, who is a Republican, have explained kind of in their own depositions what this really means, what's factual, what's an error, what actually happened, and why. But then the affidavit says, but if these things had been done intentionally, then it's a federal crime. That's true, but it's troubling because it has the potential to turn any error into an opportunity for federal intervention. If the assertion that if it was intentional, it would be a crime, which is an absolutely correct statement, without underlying evidentiary support that it was intentional, if that becomes a justification for federal intervention, I think we could see a lot of election night litigation if that's going to suffice to intervene at a federal level. And I think that could get very messy very quickly.
That does seem like a problematic standard for justifying this search. And it also
I will
seems,
say, oh, yeah.
I was going to just say, it's not unique to election law. I mean, if that can become a standard, the whole world is different. And doesn't that ultimately mean that we can't really expect that standard to last? Won't it be?
Yeah, and it's one of the kind of somewhat puzzling things that there's still some information that I have not personally seen. And the judge who issued that warrant is, said to be a pretty good judge. So it is interesting to me what the underlying justification for that was. And maybe that there's litigation going on in state court where there's going to be ongoing process. Maybe we'll understand that there's some sort of cabining happening that's just not obvious on the face of the document.
Lori, you just mentioned the warrant issued by a federal judge. Can you talk about your view of the role of the judiciary in the development of American election law? You mentioned Reynolds before. How important have the courts been in shaping the relationship between voters and elections and the government that they elect?
Oh, I think the court has been hugely important, but not always in one direction, right? Like everything with the Supreme Court, it has been a mixed bag. You saw the Tony, you know your history very well. After the Reconstruction Amendment, after the Civil War, the Reconstruction Amendments, the 14th and 15th in particular, the Supreme Court, as Reconstruction was failing, the Supreme Court really made some choices that restricted what at least could have been the scope of congressional power to enforce and I don't want to say define, but kind of shape the meaning of those amendments. And the Supreme Court put a pretty tight leash on congressional power in ways that, were not obviously what was intended by at least some of the radical Republicans who wrote and ratified those amendments. So the court's initial kind of foray into election law was not a real it was more constraining of voting rights broadly defined than we might think of if we think of like what the Warren Court did, a century later, when they interpret some of the same language very, very broadly to give Congress a lot more power. We also, of course, have cases like Bush v. Gore. That's judicial intervention in nuts and bolts election counting. In a way that was obviously quite controversial in an election that was genuinely close. I mean, we sometimes talk about elections as close that are, not necessarily really close. Bush v. Gore was breathtakingly close in Florida. And the Supreme Court interjected itself into that dispute, especially for those of you who remember this. They issued a stay early on that stopped the counting in Florida, that then made it very difficult for a what the court would have seen as a more constitutionally legitimate counting process to go forward because the stay had been in effect. Deeply controversial. And the court today has kind of a mixed bag on voting rights as well. I do think that the court should get some credit. In the recent controversies, the court was pretty good about saying, the lower courts have spoken here in the 2020 election controversies. They didn't take the bait that was being dangled in front of them in a couple of cases. So that was kind of a win for the rule of law in that particular context. But, the court's probably going to deeply constrict the Voting Rights Act, perhaps by the time this podcast airs. So it has very much been involved. It's been all over the story, but it hasn't done so in one direction, ideological direction or the other consistently.
Lori, can I ask a question that comes at this from a very different perspective?
Yeah.
To what extent your work writing this book has affected your teaching, has affected what you teach or how you teach or who you teach?
Yeah. So I might answer that question in the reverse. The book kind of comes out of my teaching. And Georgia, like many schools now, the law school we offer classes to undergraduates. We offer an undergraduate minor in the law. And I was one of the our dean, this was completely voluntary, but he asked if any of us would be willing to teach to undergraduates. And I said, sure, why not? So I developed a course. I call it Democracy in the Constitution. And the course is basically election law without a lot of doctrine. And that made me realize, well, a couple of things. First of all, the students they wanted to know this stuff. They just really were interested. And it made me realize that you can say a lot about the way the Constitution shapes our elections without needing to dive deeply into kind of the doctrinal materials that we instruct our law students on. There is some doctrine in the book. It's impossible to avoid in its entirety. But the book really grew out of that experience teaching undergraduates, especially combined with COVID, because I was teaching that undergraduate class for the first time during early COVID. So we were recording all of our lectures. So I was actually writing myself scripts for my lectures. And at some point I looked at those and I thought, this looks like a first draft. So that really generated the book. And I think it also, to answer the question you actually asked, it has changed my teaching a little bit, in that I feel like doing the writing has one of the things I was very careful about in this book, I really wanted to speak to a broad audience. And this was another thing the publisher and I had a little fisticuffs about. I didn't want it to be kind of a uh, uh, advocacy book. I wanted to genuinely explain these things because I think people want to know. They want to understand what these rules are. And people of good faith, I think, are hungry for that type of information. And I definitely got that from my undergraduate students. So I wanted to present information in a way that was fair and accessible. And whenever you go through the process I mean, writing is learning, and it clarifies, crystallizes. I hope that it has improved the clarity of my teaching as well, because when you write something, you know it better.
Lori, speaking of teaching, is there something that the students, the undergraduate students you've taught, something that they don't know about election law or the Constitution that surprises you? Or maybe I should ask, how many things surprise you about what they don't know?
Yeah, I think they know a lot of stuff shallowly, right? I mean, they certainly know that we don't directly elect the president. I'm not sure I would have known that at their age. That was before, it became a thing that suddenly the popular vote loser might regularly, or at least somewhat regularly, win the presidency. So they know that. They know we have a Senate, and they know that every state gets 2 senators. I think what they don't know, kind of collectively and generally speaking, is the why behind that, right? What are the trade-offs? Like the Senate and the House of Representatives, right? A classic set of trade-offs where you're trying to both create a federal government that has to have some direct connection to the people, because it is going to be more powerful than the Articles of Confederation that it replaces. So you need some direct accountability. A lot of the most famous founders very much thought representation should be divided equally among the population. But of course, famously, the small population states weren't going to stand for that. So we get this bifurcation. We get a Senate that kind of honors states as states, and a House of Representatives that's population based, and the Electoral College, which actually is a hybrid of both of those ideas, right? So the notion that you can think about representation as supporting any number of these different combinations of things, and that we chose our combinations for particular reasons. I think that's one of the things that is most generative for them. The idea like, oh yeah, there's lots of ways we could do this, and our way has particular causes within our system that maybe we want to keep and maybe we don't.
So speaking of things we want to keep and things we don't, what would be on your wish list for changes or improvements to elections in the US?
Yeah. So I get this question a fair amount whenever I talk about the book, because one of the things that I try to do in the book is kind of encourage people that there's a lot we actually could change. Some of these things, much of what people don't like is constitutionally entrenched. It's hard to change the Constitution, but actually kind of a surprising amount of it isn't. So when I answer that question, I try to focus on the things that don't require constitutional amendments. So my first thing is we have to fix Congress. You can't, within our system, a lot of the challenges that we see right now are because Congress just isn't functioning very well because of hyperpartisanship. We have separation of powers. You map hyperpartisanship onto separation of powers, and you get dysfunction. And that's what I think we are experiencing right now. And I think there's ways you can bring down the partisan temperature in Congress that can be done by statute. We don't have to have single member winner take all districts. We could have multi-member districts done kind of in appropriate ways that enable more of this Madisonian pluralism to happen. You can have smaller parties might have a chance of winning a seat in a multi-member district. And then maybe you have shifting coalitions in Congress on different issues. You can have fusion voting. You can have instant runoff voting. You don't have to have partisan primaries. There's a whole menu of things that scholars and advocates have looked at that can bring down the congressional temperature. So I think that would be very high on my list. And all of that is just a function of statute. We can do everything that I just said as a map for Congress, as a matter of federal statutory law, and states can experiment with it right now for their state legislatures or even their, in some cases, federal elections within their state. So that's number one. I also think we should grow the House of Representatives. The number of people who sit in the House of Representatives, the number of seats, is also just set by federal law. And the original calculation in the federal statute was designed to have a House, a population in a House district of about 30,000 people. And they thought that was much too big to be the people's house, to be the place where the people in all of kind of their diversity were represented. We're now at about 850,000 people per congressional district. I think that has some negative effects. It's very alienating. You don't feel represented because there's just too many people in each district. And again, if we had smaller district, geographically concentrated parties would have a better chance of winning a seat at the table. And that can kind of change the way partisanship plays out in the legislative process. And then the last thing on my wish list, and this is often perceived as just, overtly political in some way, and I really push back against that. I think it is a travesty that DC is not a state. Again, just a statute. You can make DC, Congress can make states. And, there are, what is it, like 700,000 Americans who live in DC who do not have voting representation in Congress. That is something I don't think we would accept anyplace else in the country, to just tell 700,000 people, sorry, you don't get a representative who gets to vote in Congress. It's more than the population of 3 states. It's pushing the population of a 4th state. And that we fought a war about that. This is like their license plates say, no taxation without representation. I don't think we would tolerate that anyplace else in the country, and I don't think we should tolerate it in DC. And I don't think the fact that it has a salient kind of predictable partisan outcome should change the matter of principle that it is simply wrong that we do not let these people have congressional representation. That's my wish list. And none of them require amending the Constitution.
Excellent. Thank you.
And how does that map onto what you would say to the voters about what they should do or we should do?
Yeah, we the voters. Yeah.
Yes.
So I think one of the goals of the book is to actually give people tools to facilitate change in their communities if they want to. And I think people can do things. All of these proposals that I've just mentioned, states can experiment with that at the state level. So at the local level, we have lots of different ways of electing local commissions, city councils. You can petition your city or your state to do instant runoff voting. Here in Georgia, we have runoffs. We are one of the states where in order to win most seats, you have to win a majority, not just a plurality of the vote. And there's lots of ways in which, there's some ways that that's bad. There's lots of ways in which it's good. We have the capacity to count instant runoff voters because we do it for our military and overseas voters. You could advocate for that. You can be an election observer, be a poll worker. If you want to understand how elections work and everything that goes into them, volunteer to be a poll worker. You'll get the training and then you'll have the information. And this is something I tell law students a lot. One of the great advantages and skills of being trained as a lawyer is we're really good at processing information. And one very good way to get information about how elections actually work is to be a poll worker and go through that process. And as a legal trained thinker, you then can have the tools and the language to take that out into your community and say, here's how this really works. Here's what I learned. And that's helpful. That's useful. And big change doesn't happen quickly, but we're all just, I quote I'm from in Georgia, Congressman John Lewis. We all just do our little piece here. You do your piece, and maybe you get to see the big change happen. Maybe you don't, but we can all do the doable.
Well, I'm afraid we're out of time. I'd like to thank Lori, Ann, and Steve for a fascinating discussion of Lori's new book. Again, We the Voters, which has just been published by Stanford University Press and is available at fine bookstores near you, as well as Amazon.com. I also would like to remind all of our viewers to not forget to like and subscribe to Law and Democracy, and look for our next episode on YouTube and Apple.